$10,000. Of course, you have a plea agreement for 18 years in the Texas Department of Corrections, but is that your plea agreement?
Yes, sir.
All right, now the agreed punishment recommendation shows Mr. Chamnish is recommending 18 years in the Texas Department of Corrections. Then you'd be ordered to pay $180 to the Department of Public Safety for the lab fee analysis. Also, pursuant to Penal Code Article 1245, do you admit and acknowledge your guilt to an unadjudicated offense of possession of a controlled substance under DA number 20-00500 and to possession of marijuana under a DA number 2000501?
Yes, sir.
Court is then taking into consideration pursuant to Penal Code Article 1245 in the plea agreement. The offense is just dictated into the record by the court. Those are considered in the assessment of the sentence following the plea agreement. So Mr. Chambliss will decline prosecution of those two offenses. All right, so do you understand, Ms. Knoll, I'm getting ready to read these allegations to you. You understand if you do plead true what your enhanced range of sentencing will be, which is set out on the second plea document?
Yes, sir.
All right. It is further presented that prior to the commission of the charged offense, you have to style the primary offense that on the 6th day of August 2018 in cause number 241-0761-18 of the 241st Judicial District Court of Smith County, it's alleged you were finally convicted of the felony offense of credit card or debit card abuse of the elderly. Is your plea to those allegations true or not true?
True.
Are you entering your plea of true to those allegations freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, the court does receive and accept your plea of true. The court does find as true the allegations in the second paragraph, which enhances your range of sentencing up to what's reflected on the acknowledgement of admonishment, the second plea document, all signed or sworn to by you. Your full range of sentencing now is not less than 15 years or more than 99 years of life in the Texas Department of Corrections. Fine may be assessed at up to $10,000. You understand in your plea agreement, which is signed by you, Kerry Knoll, and also by Mr. Davidson, your attorney, and Mr. Chambliss, state's attorney, on your plea of guilty, the state's going to recommend your sentence at 18 years in the Texas Department of Corrections, which will be assessed with credit for time served. Also, you'd be ordered to pay $180 to DPS for the lab fee. Is that your plea agreement?
Yes, sir.
All right. All these are signed by signature. I can easily read Kerry Knoll, but I just have to ask you for the record. Is that your signature on all these documents? They're above where it says defendant.
Yes, sir.
Did you go reach one of these plea documents with Mr. Don Davidson, your attorney, so he explained each plea document to you before you signed and swore to it?
Yes, sir.
All right, so we've been over your plea agreement. There's an acknowledgement of admonishments, 5 admonishments that gives you what is now the full range of sentencing, a total of 5 admonishments. Explanation, you have signed below the 5th one with your attorney, Mr. Davidson. You've signed a waiver of trial by jury, which waives up your right to trial by jury and tells the court you just wish to proceed on your plea of guilty without a jury. Is that correct?
Yes, sir.
All right, the waiver of trial by jury is approved. You signed and sworn to a waiver of confrontation with witnesses. You have signed and sworn to, Ms. Knowles, stipulation of evidence. That's stage 2. It's on the screen right there in front of you. The stipulation of evidence, need to be sure you do understand that stipulation of evidence is a written judicial confession under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes, sir.
Did you sign and swear to the stipulation of evidence of your own free will and sign and swear to it voluntarily?
Yes, sir.
All right, court approves the signed and sworn to stipulation of evidence, signed and sworn to by the defendant, signed by her attorney and state's attorney. Then we've got an agreement to stipulate testimony on the plea. Ms. Knowles, do you understand you have signed, along with Mr. Davidson, a waiver of a motion for new trial and a waiver of your right to appeal?
Yes, sir.
All right. In addition, the court has the request to allow a waiver of the pre-sentence, which is approved by the court. The trial court certification of the defendant's rights to appeal, signed by the defendant and her attorney, which will be later signed by the court, which will reflect this is a plea bargain case and the defendant has no right of appeal, and also the defendant has waived her right to appeal. The other document that we have is advice where you've signed and sworn to advice you received from Mr. Davidson on your rights to appeal. Do you understand all these documents?
Yes, sir.
Do you still wish to go forward on your plea of guilty to the indictment without a jury?
Yes, sir.
All right, do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any type drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today? And have you been over everything you're doing in court today with your attorney, Mr. Davidson?
Yes, sir.
Have you been over everything about the facts of your case with your attorney, Mr. Don Davidson?
Yes, sir.
Is she competent, Mr. Davidson?
Yes, Your Honor.
Any evidence of incompetence, Mr. Chambers?
No, Your Honor.
No, State's counsel signed his consent, approved the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers and documents in the case for the plea, signed or sworn to by the defendant, signed by our attorney. All right, understanding all the allegations, the charge in the indictment, the full range of sentencing, your plea agreement, and all these plea documents, do you have any questions for me about anything, Ms. Noble?
No, sir.
All right, in cause number 241-0286-20, what is your plea today to the indictment charging you with the offense of manufacture and delivery of a controlled substance enhanced up to a sentencing range of not less than 15 years, nor more than 99 years for life in the Texas Department of Corrections Institutional Division?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way, promised you anything, or coerced you to enter your plea of guilty?
No, sir.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, sir.
Has anyone threatened you in any way or promised you anything to get you to enter a plea of guilty?
No, sir.
Are you entering your plea of guilty to the indictment today because you have any type of delusion in your mind or any type unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty. What do you have, Mr. Chambers?
Your Honor, at this time, we would offer States 1, the plea packet, States 2, the signed and sworn to stipulation of evidence, and States 3, the discovery compliance acknowledgement.
No objection.
With no objections, States Exhibits 1, 2, and 3 are admitted into evidence. States 1 being all the plea documents identified on the record by the court, signed and sworn to by the defendant, signed by her attorney and State's attorney. Those are all admitted in under States 1. States 2, signed and sworn to stipulation of evidence, the written judicial confession to the allegations in the indictment, signed and sworn to by the defendant, signed by her attorney. That's admitted in with no objection to States 2. States 3, discovery compliance, approved by the court, admitted into evidence to States 3. The court does find the defendant's waiver of her rights and her execution of all the other documents in this case were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the indictment, and the court, based upon the plea of guilty and the evidence submitted in the record, the court does find the defendant guilty of the offense alleged against her by the state in its indictment, manufacture, delivery of a controlled substance more than 4 but less than 200 grams as alleged in the indictment. Moving to sentencing.
Your Honor, we would offer States 4, which is a digital copy of the state's written discovery.
No objection.
States 4, all the offense investigative reports, the DPS lab report approved by the court admitted into evidence as State's Exhibit 4. The court in this case, having received and accepted the defendant's plea of guilty to the offense alleged in the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily, the court does find the defendant guilty of the offense alleged in the indictment, and the court, following the plea agreement and the recommendation of the state, the court assessed the sentence in the case at 18 years in the Texas Department of Corrections Institutional Division. No fines assessed, court costs are ordered paid. Restitution is ordered at Department of Public Safety Lab in the amount of $180. The court has considered the two offenses under 1244 that the court has earlier dictated into the record, which are reflected on the front plea documents. those two offenses of PCS and possession of marijuana will be declined by the state as part of the plea. You understand, Ms. Knoll, I have received from you a waiver which gives up your right to appeal and a waiver which gives up your right to file a motion for new trial.
Yes, sir.
Are you waiving those rights freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, court receives the waiver of appeal, approves it along with the waiver of right to file a motion for new trial filed by the defendant, all these signed by the defendant and her attorney. The court then, in this cause number, based upon the defendant's plea of guilty to the offense alleged in the indictment and the evidence presented and admitted into the record, the court, following the plea agreement, assessed the sentence at 18 years in the Texas Department of Corrections Institutional Division with credit for time served, $180 ordered DPS for the lab fee. Court has considered the two offenses pursuant to Article 1245. Sentence is formally pronounced. Waiver of appeals accepted. Defendant is continued in custody until such time as she can be transported to the Texas Department of Corrections Institutional Division to serve the sentence assessed by the court following the plea agreement, the recommendation of the state at 18 years in the Texas Department of Corrections Institutional Division with credit for time served. Ms. Knoll, Mr. Don Davidson has been your court-appointed attorney. Are you satisfied with Mr. Davidson's legal representation?
Yes, sir.
Anything further, Mr. Davidson? Anything
No.
further?
No.
Anything further, Mr. Chambers?
No, Your Honor.
All right, the defendant's continued in the custody of the sheriff until she can be transported to the Texas Department of Corrections Institutional Division, serve the 18-year sentence assessed by the court with credit for time served, court following the plea agreement in the case. If there's nothing further, we'll be in recess.
Ms. Knoll, will you ask them to I need Bobby Sherry.
Yes, ma'am.
Thank you.
Bobby Sherry.
All right, we're on the record in cause number 241-1896-19 by Zoom. State versus Bobby Sherry, S-H-A-R-Y, present before the court. On Zoom from the jail, her attorney, Mr. Don Davidson, is present before the court by Zoom. Mr. E. Chamness is representing the state, present by Zoom. The court's probation officer is also present by Zoom. Mr. Davidson, do you want to waive the reading and formal presentation of the indictment and all the other formalities?
Yes, Your Honor.
Ms. Sherry, just raise your right hand. I have to swear you in. Do you solemnly swear the testimony you'll give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, and that all the documents which reflect that you signed the document and then swore to it were signed and sworn to by you freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, first of all, Ms. Sherry, the indictment in the case charging you with the offense of possession of a controlled substance, alleging you did in there intentionally and knowingly possess a controlled substance, namely methamphetamine, in an amount of 1 gram or more, but less than 4 grams, including any adultery and eludence. The full range of sentencing for that offense, it's a third-degree felony as alleged, carrying a sentencing range of not less than 2 years, nor more than 10 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. Do you understand that?
Yes, sir.
All right, now I've got a set of plea documents here. The first one going up is going to be your agreed punishment recommendation. There's a signature down at the bottom, signed Bobby Sherry, but I have to ask you for the record. Is that your signature?
Yes, sir.
That signature is on all the plea documents, the ones that now show you have signed and sworn to them, and the ones which just bear your signature. Have you gone over all these plea documents before you signed and swore to the plea documents with your attorney, Mr. Don Davidson, so he explained the plea documents to you?
Yes, sir.
You have a plea agreement in the case where if you do enter a plea of guilty to this offense of possession of controlled substance, third-degree felony as alleged in the indictment, Mr. Chan, the state's attorney is going to recommend to the court your sentence be assessed at 4 years in the Texas Department of Corrections Institutional Division. That would be assessed with credit for time served. Also, you'd be ordered to pay $180 to the Department of Public Safety for the lab fee on the controlled substance. Is that your plea agreement, Ms. Sherry?
Yes, sir.
Is that it, Mr. Davidson?
Yes, Your Honor.
that your recommendation, Mr. Chambliss?
It is, Your Honor.
All right, in addition, the court has an acknowledgement of admonishments, Ms. Sherry. It has 5 admonishments in it. You've signed or signed and swore to these plea documents, all signed by your attorney. Do you understand all 5 admonishments under the acknowledgement of admonishments?
Yes, sir.
There, you understand you've signed along with Mr. Davidson and the state's attorney. You have waived by your waiver of trial by jury. You have waived giving up your right to a trial by jury and just asked the court to hear the case on your plea of guilty before the court without a jury. Is that correct?
Yes, sir.
Also, you've waived, signed and sworn to a waiver of confrontation with witnesses. Going up on the screen will be a stipulation of evidence, State's Exhibit Number 2, now signed and sworn to by you. Do you understand the stipulation of evidence signed and sworn to by you is a written judicial confession under oath by you to the allegations and the charge in the indictment?
Yes, sir.
Did you sign and swear to that stipulation of evidence of your own free will and sign and swear to it voluntarily?
Yes, sir.
There's an agreement to stipulate testimony on the plea. There is a form signed by the defendant and her attorney waiving her right to file a motion for new trial, waiving giving up her right to appeal. There's approval of waiver of the pre-sentence investigation. There's a trial court certification of her rights to appeal, which would reflect this also signed by the defendant and her attorney that this is a plea bargain case and the defendant has no right of appeal and the defendant has waived the right of appeal. There's the advice of signed, sworn to by the defendant on advice she's received from her attorney on her right to appeal. Now, understanding all these plea documents, the allegations, the charge in the indictment, and your plea agreement, do you still wish to go forward on your plea of guilty to this indictment, charging possession of controlled substance, 3rd-degree felony, as alleged, without a jury?
Yes, sir.
Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today, as well as the facts of your case with your attorney, Mr. Don Davidson?
Yes, sir.
Is she competent, Mr. Davidson?
Yes, Your Honor.
Any evidence of incompetence, Mr. Chambers?
No, Your Honor.
State's counsel signed his approval of waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers signed are signed sworn to by the defendant, signed by her attorney. All right, you do understand all the allegations, the charge in the indictment, the full range of sentencing, all your plea documents, and your plea agreement. Is that correct, Ms. Sherry?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 241-1896-19, what is your plea today to the indictment charging you with the offense of possession of a controlled substance, a 3rd-degree felony, as alleged in the indictment?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Correct.
Has anyone
Yes, sir.
has anyone threatened you in any way, promised you anything, or coerced you, made you enter this plea of guilty?
No, sir.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment because you have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty to the indictment. What do you have, Mr. James?
Your Honor, at this time, we would offer States 1, the plea packet, States 2, the sign and sworn to stipulation of evidence, and States 3, the discovery compliance.
No objection.
With no objection, States 1 on plea document, States 2 the signed and sworn to written stipulation of evidence, States 3 discovery of compliance, all approved by the court, admitted into evidence, States Exhibits 1, 2, and 3 with no objection. Court having admitted into evidence, State Exhibits 1, 2, and 3, the court does find the defendant's waiver of her rights or execution of all the plea documents were all done by the defendant freely, intelligently, knowingly, voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in the case was entered by the defendant to the indictment in the case freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the indictment, and then the court does find the defendant guilty of the offense alleged in the indictment, possession of a controlled substance, a 3rd-degree felony, as alleged in the indictment. Moving to sentencing, Mr. Chairman.
Your Honor, we would offer states 4, which is a digital copy of the state's written discovery.
No objection.
With no objection, states 4 on one. Offense, investigative reports, DPS, lab report, all admitted into evidence with no objection. Court having received and accepted the defendant's plea of guilty, the court finding the defendant guilty of the offense alleged against her by the state in its indictment based upon the plea of guilty and the evidence admitted into the record. The court follows the plea agreement, assesses the sentence in the case at 4 years in the Texas Department of Corrections institutional division with credit for time served. No fines, escort costs are ordered paid. Restitutions are Department of Public Safety in the amount of $180 for the lab fee analysis. Any legal reason for formal sentencing?
No, Your Honor.
All right, sentence is formally pronounced 4 years in the Texas Department of Corrections institutional division, assessed credit for time served. No fines, escort costs are ordered paid. Restitutions ordered DPS lab. Waiver of appeal is accepted. Waiver of motion for new trial is accepted. Sentence is formally pronounced. It's ordered by the court. Defendant, Ms. Sheriff, be continued to the custody of the sheriff until such time as she can be transported to the Texas Department of Corrections institutional division to serve the 4-year sentence assessed by the court. Following the plea agreement, 4-year sentence being assessed with credit for time served. Ms. Sherry, your court-appointed attorney has been Mr. Don Davidson. Are you satisfied with Mr. Don Davidson's legal representation?
Yes, sir.
All right, there's nothing further. We'll be in recess. The defendant's continued the custody of the sheriff, as the court has said, until she can be transported to the Texas Department of Corrections institutional division, serve a 4-year sentence assessed by the court with credit for time served. Court had. Is there anything else from either the state or defense?
No, Your Honor.
Not from the state, Your Honor.
We're in recess.
Ma'am, would you let them know we need Sherman Neat Dorsey?
Yes, sir. Thank you.
Thank you.
All right, we're on the record by Zoom and calls number 2410926-20. State versus Shermanique Dorsey, Shermonique Dorsey, Dorsey. This is on a charge of driving while intoxicated with a child under 15 years of age. State jail felony is alleged in the indictment, carrying full range of sentencing of up not less than 180 days to more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. Do you waive the formal reading and presentation of the indictment, Mr. Davis?
Yes, Your Honor.
All right. Ms. Dorsey, raise your right hand so I can get you sworn in. Do you solemnly swear the testimony you'll give in the cause down trial will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, do you further swear the documents we show on the document you signed and then sworn to the document were signed and then sworn to by you freely, intelligently, knowingly, and voluntarily? I mean, do you understand the documents you signed and swore to?
Yes, sir.
And did you sign and swear to those documents freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, first of all, we're going to go over your plea documents here. The first one's going, first of all, do you understand the allegations, the charge in the indictment, and the full range of sentencing?
Yes, sir.
You understand the state's recommending on your plea of guilty. If you do enter a plea of guilty, your sentence will be assessed at 12 months in a state jail facility. That'll be assessed with credit for time served. There's a check by a special condition on restitution to be determined by PSI. Do we need a post-sentence, Mr. Chambers? Do we need a post-sentence? Is there any restitution due?
I think there may have been a blood draw.
That's my question. It being a driving while intoxicated with a child under 15 years of age, the question would be, was there a blood draw? If there was a blood draw, then the court would be assessing restitution to the Department of Public Safety in the amount of $60 for the blood draw.
That's correct, Your Honor.
All right. Set your plea agreement, Ms. Dorsey. If you plead guilty, state's attorney is going to recommend 12 months in a state jail facility, be assessed with credit for time served. You'd be ordered to pay $60 for the blood draw by DPS. Is that your plea agreement?
Yes, sir.
Say that, Mr. Davidson.
It is, Your Honor.
It's your recommendation, Mr. Chambers.
It is, Your Honor.
All right, now here's the plea documents I've got, Ms. Dorsey. They're all signed Shermanick Dorsey, but that is, I have to ask you, that is your signature, is that correct?
Yes, sir.
All right, so we've been over your plea agreement for 12 months in state jail facility with credit for time served, restitution order for the blood draw. I've got all these documents are signed or signed and sworn to by you and signed by your attorney. There's 5 admonishments and acknowledgement of admonishments. You are waiving, giving up your right to trial by jury, just asking the court to hear the case on your plea of guilty without a jury. Is that correct?
Correct.
You signed a waiver of confrontation with witnesses. You signed and sworn to a stipulation of evidence, Ms. Dorsey. Do you understand that's a written judicial confession under oath by you to all the allegations and the charge in the indictment?
Yes, sir.
Did you sign and swear to this stipulation of evidence states too of your own free will and sign and swear to it voluntarily?
Sir.
Is there agreement to stipulate testimony form for a waiver of appeal, waiving motion for new trial, request to allow waiver of the pre-sentence, which is approved by the court, the trial court certification of your rights to appeal, signed by you and Mr. Davidson, which will reflect, it'll be signed by the court. This is a plea bargain case. You have no right of appeal, and also it's indicated that you have waived your right of appeal by this written waiver you filed with the court. Then you've got a document signed and sworn to by you and advice the defendant's rights to appeal. Now, understanding all these plea documents, including your plea agreement, do you still wish to go forward on your plea of guilty to this indictment today without a jury?
Yes, sir.
All right, do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or been under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today with your attorney, Mr. Don Davidson, as well as the facts of your case with your attorney, Mr. Don Davidson?
Yes, sir.
Is she competent, Mr. Davidson?
Yes, Your Honor.
Any evidence of incompetence, Mr. Chambers?
No, Your Honor.
No state's counsel signed his consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed or sworn to by the defendant, signed by our attorney. All right, understanding all the allegations, the charge in the indictment, the full range of sentencing, your plea agreement, and all your plea papers, do you have any questions for me, Ms. Dorsey?
Yes, sir.
Okay, do you have any questions for me?
Yes, sir.
Okay, what's your question?
When do I need to pay the $60 in fine?
Well, in all likelihood, when you parole out of the Texas Department, I'm sorry, out of a state jail facility, I mean, you can pay it whenever you want to. It's attached as a condition of your sentence in a state jail facility.
Okay, is that the only time that I have to pay, or is that a continued thing?
No, you pay one $60 fee through the probation department, which is then forwarded on to the Texas Department of Corrections, to the Department of Public Safety. It's for the lab, it's for that blood draw where they put a needle in your arm and draw the blood out.
Okay.
Okay?
Yes, sir.
Any other questions?
If I could, can I have a copy of everything?
Sure, Mr. Davidson can provide you a copy of everything.
Yes, sir.
He has a copy of all these plea papers we've been over.
Okay.
All right, anything else?
No, sir.
All right, the court in this case then, finding the defendant competent to enter a plea, the court the case finding all the plea documents signed or sworn to by the defendant, or all done by the defendant freely, intelligently, knowingly, and voluntarily. Let me be sure I've got this. I do so many of these, Ms. Darcy. I need to be sure that I have got your plea in cause number 2410926-20. What is your plea today to the indictment charging you with driving while intoxicated with a child under 15 years of age, a state jail felony?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way or promise you anything to plead guilty?
No, sir.
You are pleading guilty to this indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment. Is that
Yeah.
correct?
Correct.
You don't have any type delusion in your mind or some type unrealistic hope of pardon, parole, or leniency. Is that correct?
Correct.
All right, court receives and accepts a plea of guilty. Okay, Mr. Chandler, what do you have?
Your Honor, we would offer states 1, the plea packet, states 2, the signed and sworn to stipulation of evidence, and states 3, the discovery compliance.
No objection.
With no objection, states 1, 2, and 3 are all admitted into evidence with no objection. The court finding all these documents were executed by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this cause number was entered by the defendant to the indictment in this cause number freely, intelligently, knowingly, and voluntarily. The court receives and accepts the defendant's plea of guilty. The court does find the defendant guilty of the offense alleged in the indictment, driving while intoxicated with a child under 15 years of age. Moving to sentencing, Mr. Chambers.
Your Honor, we would offer states 4, which is a digital copy of the state's written discovery.
No objection.
The state's for is admitted into evidence without objection. All the offense investigative reports and the report on the DPS blood draw. The court in this case then, having received and accepted the defendant's plea of guilty, the court does find the defendant guilty of the offense of driving while intoxicated with a child under 15 years of age as alleged in the indictment. The court follows the plea agreement, the recommendation of the state, and assesses the sentence in the case at 12 months in the state jail facility, assessed with credit for time served. Restitution is ordered to DPS in the amount of $60 for the lab fee analysis. Sentence is formally pronounced at 12 months in the state jail facility with credit for time served. Restitution ordered to DPS in the amount of $60. Waiver of appeal filed by Ms. Dorsey and the waiver of her right to file a motion for new trial, both accepted by the court. Both waivers signed or signed and sworn to by the defendant, signed by her attorney. Waivers of appeal are accepted. Anything else, Mr. Chambliss?
No, Your Honor.
Anything else, Mr. Davidson?
No, Your Honor.
All right, it'll be the order of the court then, Ms. Dorsey's continued to the custody of the sheriff until she can be transported to a state jail facility to serve the 12-month sentence assessed by the court following the plea agreement. 12-month sentence is assessed with credit for time served. Restitution ordered to the Department of Public Safety in the amount of $60 for the blood draw. Waiver of appeal accepted. If nothing further, we'll be in recess, and the defendant, Ms. Dorsey, is continued in the custody of the sheriff till she can be transported to a state jail facility to serve the sentence assessed by the court with credit for time served, restitution order. We're in recess.
Ma'am, would you let them know we need Calvin Moss?
Okay.
He's at low risk.
Calvin.
Oh, he's at low risk. Okay, never mind. I'm sorry, Bradley Rhodes.
Bradley Rowe.
Oh, about zooming.
All right, the court is calling by Zoom, calls number 241-08-24-19, State versus Bradley Stephen Rhodes, present before the court by Zoom on the indictment in this call's number charging possession with intent to promote child pornography. Also, the court is calling calls number 241-0585-20, on an indictment charging sexual abuse of a child, continuous victim under 14. Court takes judicial notice of all the prior proceedings in both cause numbers. In addition, the court does take judicial notice of the report received, which is in the file by court. We may have covered this
We did.
before.
We did.
Okay, well, my court coordinators told me I've gone over all the, regarding the report. Dr. Proctor performed and sent to the court, finding the defendant competent to stand trial. Apparently that's already in the record and the court takes judicial notice of it. So in looking at the docket sheet to try to figure out where we are today, I noticed on the back on the docket sheet, one of the docket sheets, July 28, 2020, the case was called by Zoom as it's being done today with the defendant present with his attorney. And it was reset for August the 25th, 2020. That appears to be the situation in both calls numbers. So what are the, Mr. Chamness, what's the state's announcement on both these calls is, I'm calling both calls numbers, both in docket sheets reflect July the 28th, 2020. Each case was called by Zoom, reset for August the 25th, 2020. So what's the state's announcements on each one of these, Mr. Chamness?
Your Honor, this is going to be a plea. It is a case where both of the defendant, according to what his attorney has told me, is going to enter a plea of guilty to both indictments. But because the continuous case has an underlying offense of aggravated sexual assault of a child, and because the defendant has previously been convicted of aggravated sexual assault of a child, I filed a Brooks notice yesterday, which Mr. Davidson is aware of. It will make the case a mandatory life case under Penal Code 1242. But Mr. Davidson and I are going to need to mark through some of the language in the continuous indictment because he's actually going to plead to an aggravated sexual assault. Then he's going to plead true to a prior conviction of an aggravated sexual assault, which will make the case a mandatory life case to be ran concurrent with the 25 to life child pornography case. That's my understanding of the agreement. If I've said anything incorrect, Mr. Davidson can correct me, but we need literally probably until next week to get the indictment set to where that the defendant is pleading guilty and pleading true on the case, which will then make it a mandatory life sentence.
All right, before I hear from Mr. Davidson, it doesn't appear that it has a file mark on it, but at any rate, I do have in this cause number 2410585-20 State versus Bradley Rhodes, and state's notice of intent to seek a higher punishment based on prior convictions pursuant to Brooks versus State. That's signed by Mr. Chamness. I also have an order granting the state's notice of intent to seek higher punishment based on prior convictions pursuant to Brooks versus State. There's an order. I've not signed the order yet. So, Mr. Chamness, you and Mr. Davidson, I'd obviously have a state's notice of intent to seek higher punishment with an order. So is that, what's the state and defense positions on that notice, Mr. Chamness?
Your Honor, Mr. Davidson has had notice of that for an extensive period of time. We had not filed that enhancement in the continuous case, but it is one of the enhancement paragraphs already in the indictment on the child pornography case. So Mr. Davidson has been aware of that conviction for an extended period of time. It wasn't until I had the opportunity to sit down and talk to the family and explain all of the different options that existed in this case that the decision was made to allow him to plead to a lesser of continuous, which is going to be aggravated sexual assault of a child, which then made it necessary to Brooks in the prior ag sex assault so that he could plead true to that, thus making him a twice convicted sex offender, which results in a mandatory life sentence.
Correct, Mr. Davidson?
That's all correct. And Judge, as you can imagine, this is fairly complicated, and we're trying to make sure we get the language correct. My understanding is that the advantage to Mr. Rhodes is obviously that they run together, that he would at some point be parole eligible because of the way we're structuring this. And so that's why we want to make sure we're getting all the language correct, and we'd like that additional week.
Well, I'll certainly grant an additional week, and I'm handed a note here by my court coordinator, which says Tuesday, September the 2nd at 9:30. That would be the date that the court would be rescheduling the cases for plea agreements and pleas following the plea agreements. September the 2nd, Tuesday, September 2nd at 9:30. Is that agreeable with state and defense?
Yes, Your Honor.
Yes, Your Honor.
All right, now, trying to follow you through this, I do still have this order obviously in front of me, and cause number 2410585-20, which is going to be the indictment charging the offense of sexual abuse of a child, continuous victim under 14. So is the state urging this notice of intent to seek higher punishment now in this cause number 2410585-20? If so, I'm going to grant it and sign the order.
Yes, Your Honor. I don't see any reason why we need to wait until next week to urge the Brooks notice. As I mentioned, Mr. Davidson and the defendant, as far as that goes, has been on notice of this particular enhancement since they've received discovery. And obviously the defendant knows what he's been convicted of in the past. So I would go ahead and urge it today.
Mr. Davidson?
Yeah, no objection. You know, that all of that is correct. And also, of course, as Mr. Chambliss pointed out, the other indictment and the enhancement in that indictment. So yeah, we have no objection.
All right, then the court has signed an order. Will be marked in today. The order granting the state's notice of intent to seek higher punishment based on prior convictions pursuant to Brooks versus State. That order is signed and entered by the court. This is the 25th day of August, 2020. That would appear to be then all that counsel are anticipating we will do today, and the case is reset for the plea. The court's going to follow the plea agreement, so we're resetting both the cases for disposition on plea agreements on Tuesday, September the 2nd at 9:30. Is that correct, Mr. Chairman?
That's correct, Your Honor.
Is that correct, Mr. Davidson?
Yes, Your Honor.
All right, well, the defendant, do you understand this, Mr. Rhodes?
Yes, sir.
All right, defendant, Mr. Rhodes, Bradley Rhodes, he's continuing in the custody of the sheriff, certainly until Tuesday, September the 2nd at 9:30, which when the court will take the pleas, if it in fact does take place, when the court will take the pleas, follow the plea agreements at that time. Anything else today then, Mr. Chambliss or Mr. Davidson?
No, Your Honor.
Nothing from the state.
All right, we're in recess to Tuesday, September the 2nd at 9:30 by Zoom. Who do you need next?
Rusty Hilliard, please.
Could you tell them that we need Rusty Hilliard? I may have stepped away from the microphone. All right, we're on the record in cause number 241-0462-20, State versus Rusty Lee Hilliard, on an indictment charging the offense of stalking with a previous conviction. His attorney, Don Davidson, is present by Zoom. State's attorney, Mr. Chambliss, is present by Zoom. Appears on August the 25th, 2020. The case was called by Zoom and reset to September the 22nd, 2020. All right, what's the state's announcement, Mr. Chambliss?
Your Honor, This is a case that obviously it's been indicted for a while, but Mr. Hilliard had Zach Davis as his court-appointed attorney. I don't know the ins and outs of that, but my understanding is that they basically didn't see eye to eye from day one. Defendant has never been presented an offer by the state at all on this case, because I was informed that it didn't matter what I offered, it was going to be a trial. Now, Mr. Davidson is now substituted in after Mr. Zach Davis withdrew, and had told me that he had just gotten a copy of the discovery, which, by the way, is pretty voluminous, and hasn't really had an opportunity to go through the discovery with his client. Mr. Davidson did not indicate to me that he did not want me to make an offer on the case, but that at this point he was not prepared to discuss an offer with his client until he could go through all the discovery. So I told him that I had no objection to agreeing to pass this today so that he could review all the discovery and review it with his client.
That's correct, Your Honor.
All right, just for the record, the court obviously has the indictment here in 241-462-20, charging the offense of stalking with previous convictions. Obviously, the stalking is alleged in the first paragraph of the indictment. And then in the second, third, and fourth paragraphs of the indictment, there are allegations of previous convictions for felony offenses, which would appear to be, if the defendant pled true to all of them, it would be enhanced up to a first degree. Is that correct, counsel?
Yes, Your Honor. The minimum on this case is 25, with life being 99 years or life being maximum.
If the defendant pleads true to the enhancement paragraphs in the indictment, the full range of sentencing would be not less than 25 years or more than 99 years or life. The Texas Department of Corrections Institutional Division. The court does take judicial notice of all of the prior proceedings and the full content of the trial file, and resets this case. Or did y'all have a date?
September.
You're on.
Okay, wait a minute. I've got one up here that from my coordinator, says Tuesday, September the 22nd at 10 o'clock.
Yes, sir. That's correct.
Is that agreeable, Mr. Davidson?
Yes, sir.
All right, is that it, Mr. Chairman, for the date?
That works for the state, Your Honor.
When you anticipate a plea? All right, we'll be in recess until Tuesday, September the 22nd at 10 o'clock for the pleas in the case. The court will call the plea agreement if there is one. And the defendants continue in the custody of the sheriff until the next hearing before the court on what appears to potentially be a plea on Tuesday, September the 22nd at 10 o'clock. Anything further, Mr. Chairman, or Mr. Davidson?
No, Your Honor.
Nothing from the state.
All right, then, Mr. Hilliard is continued in the custody of the sheriff until that date. At that time, the court will hear a plea and the plea agreement if there is one. You understand all this, Mr. Hilliard?
Yes, sir.
All right, we're in recess to Tuesday, September 22nd, 10 o'clock.
Okay.
I can't stick it on the file. It's-
Yeah, I know, I wrote
There
on
you
the
go.
wrong side.
That's, gosh.
Okay. Okay, go.
All right, we're over low risk now. Have apparently two indictments. Cause number 241-087320 and cause number 241-087420. Both these indictments are State versus Calvin Moss, who is present before the court by Zoom. With his attorney, Mr. Don Davidson, by Zoom. Ms. Anderson, State's counsel, is present by Zoom. Mr. Davidson, do you wish to waive the formal reading and presentation of the indictments in each cause number?
Yes, Your Honor. His name is set forth correctly. We'll waive the reading of the indictment in each case.
All right, Mr. Moss, just raise your right hand. I have to swear you in. Do you solemnly swear the testimony you'll give in the cause is now on trial will be the truth, the whole truth, and nothing but the truth, and that you have signed or signed and sworn to these documents all freely, intelligently, knowingly, and voluntarily?
Yes.
All right, with the waiver of indictments being entered in each cause number, going by the numbers, the first indictment charges the offense of driving while intoxicated, third or more with priors alleged. And also over in cause number 2410874-20, that's a state jail felony charge of possession of a controlled substance with 2 prior felonies alleged, second and third paragraphs. It appears that in each indictment, there's a prior alleged for burglary of a building. These are going to be up on the screen. You can actually see them, Mr. Moss. There's a prior alleged for burglary of a building. And then there's also a prior alleged for driving while intoxicated, third or more. You can see that in the third and fourth paragraphs. Those are priors that enhance the sentencing range. So we start off with driving while intoxicated, third or more as alleged in the first paragraph. The second paragraph alleges 2 prior convictions for driving while intoxicated. So I'm going to read it to you first and ask you whether or not your plea to it is true or not true. This is in 2410873-20, where you're charged with driving while intoxicated, third or more. If you plead true to the to the allegations of prior DWI convictions as alleged in that second paragraph you're looking at, the court will find those allegations true, and then the driving while intoxicated charged against you by the state in its first paragraph will become a third-degree felony, carrying a sentencing range of not less than 2 no more than 10 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. Do you understand that?
Yes.
They're right on the screen. I'm getting ready to read them to you. These are the allegations in the second paragraph of cause number 2410873-20, where you're charged with driving while intoxicated, third or more. It's further presented that prior to the commission of the charged offense, hereinafter style the primary offense, that on the 25th day of April 2000, in cause number 26895, in the county court of Wood County, Texas, is alleged you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Are those allegations true or not true?
Yes.
Are they true?
True.
And then it's alleged that on the 15th day of November 2001, in cause number 27682, in the county court of Wood County, Texas, it's alleged you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Are those allegations true or not true?
True.
Are you entering your plea of true to each one of these allegations in the second paragraph of the indictment, freely, intelligently, knowingly, and voluntarily?
Yes.
No one's threatened you in any way or promised you anything to enter either one of these pleas of true. Is that correct?
Correct.
All right, the court does receive and accept the pleas of true, and the court does find as true the allegations in the second paragraph of the indictment alleging 2 prior convictions for driving while intoxicated, which now enhances the sentencing range for the driving while intoxicated alleged in the first paragraph up to that of a third-degree felony, carrying a sentencing range of not less than 2 no more than 10 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. Do you understand all that, Mr. Moss?
Yes.
Now, Mr. Moss, we need to take up in each indictment what are called enhancement paragraphs. The third paragraph there, right below the allegations of the 2 prior DWIs you just pled true to, there's an enhancement paragraph that is the same in each one of these indictments. It's there in the third paragraph in the indictment where you're charged with driving while intoxicated, which is on the screen. It alleges a prior felony conviction for the offense of burglary of a building. Then when you go to the last paragraph of this indictment, you have another enhancement paragraph which alleges a prior felony conviction for driving while intoxicated. Now, those 2 enhancement paragraphs are the same in each indictment. If you enter a plea of if you enter a plea of true to those enhancement paragraphs in each indictment, it's going to increase your range of sentencing in each cause number. Do you understand that?
Yes.
If you enter pleas of true to these enhancement paragraphs, the third and fourth paragraph of the indictment, the one that charges you with driving while intoxicated, third or more, right now your sentencing range for that offense is alleged in 2410873-20 stands at not less than 2 years to more than 10 years. And in the Texas Department of Corrections Institutional Division, fine may be assessed of up to $10,000. When I read each one of these enhancement paragraphs, the third and fourth, if you enter pleas of true to the allegations of a prior felony conviction for burglary of a building, and then you enter a plea of true to a prior felony conviction for driving while intoxicated, as alleged in the third and fourth paragraphs of the indictment, it will increase your range of sentencing for this offense of driving while intoxicated, third or more, is charged in this indictment up to a habitual range. Your minimum will be 25 years in the Texas Department of Corrections Institutional Division, up to a maximum of 99 years of life in the Texas Department of Corrections Institutional Division. Do you understand that?
Yes.
Now, going over to the next indictment, because I'm going to read both the enhancement paragraphs to you and then take your pleas at the same time for purposes of both indictments. So going over to the other indictment, 2410874-20, you're charged with a possession of a controlled substance less than a gram. That is a state jail felony offense, carrying a sentencing range of not less than 180 days or more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. When I read the allegations in the third paragraph to you, and if you enter a plea of true to those allegations, then I read the last paragraph, the second enhancement paragraph to you, and you enter a plea of true to those allegations, they both allege prior felony convictions, it will enhance or increase your range of sentencing for the possession of a controlled substance up to a second degree felony, carrying a sentencing range of not less than 2 to more than 20 years in the Texas Department of Corrections Institutional Division, and a fine of up to $10,000. Do you understand that?
Yes.
Now, do you understand, Mr. Moss? I'm going to read each one of these paragraphs. The third paragraph in the indictment charging driving while intoxicated, and the second paragraph in the indictment charging possession of a controlled substance less than a gram. And I'm going to ask you whether or not your plea to those paragraphs, which are exactly the same in each indictment, is true or not true. And then I'm going to read the last paragraph of the indictment to you. That's the last paragraph of each indictment, which is the same, which alleges a prior felony conviction of driving while intoxicated, third or more. If you enter pleas of true to the allegations in the third and fourth paragraph of the indictment that was just up on the screen, then you enter a plea of true to the allegations in the second, third paragraph of the indictment charging you with possession of a controlled substance. What you will be looking at is a full sentencing range of not less than, as I've mentioned, not less than 25 years to more than 99 years of life in the Texas Department of Corrections for the offense of driving while intoxicated, third or more, in 087320, and then over in 087420, where you're charged with a state jail. Over in that one, pleas of true to both the enhancement paragraphs, you'll be looking at a full sentencing range of not less than 2 no more than 20 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. Do you understand all that?
Yes.
Of course, this is all set out in the plea papers that I'll go through and identify after I take your pleas. So we'll start with cause number 2410873-20. I'm going to ask you whether or not your plea is true or not true to the third paragraph of that indictment, which alleges a prior conviction for burglary of a building. At the same time, I'm taking your plea of either true or not true to the second paragraph of the other indictment alleging a prior felony conviction for burglary of a building. In other words, I'm taking your pleas to these paragraphs in each indictment, which enhance your range of sentencing, as I've explained to you. I'm taking both the pleas at the same time because the allegations in these paragraphs are the same. Do you understand all that, Mr. Moss?
Correct.
All right, it's further. We start then in 087320 and then at 087420. Both the allegations in these enhancement paragraphs I'm getting ready to read are the same in each indictment. I'm I'm going to receive and accept your pleas to the allegations in each pair of these two paragraphs in each indictment at the same time. Each one of these paragraphs in each indictment alleges, and it's further presented, that prior to the commission of the charged offense, hereinafter style the primary offense in each indictment, it's alleged that on the 28th day of April 1995, in cause number 791-416 in the 7th Judicial District Court of Smith County, Texas, it's alleged you were finally convicted of the felony offense of burglary of a building. Is your plea to those allegations as alleged in both indictments true or not true?
True.
Now we're going to move down to what is the last paragraph in 0873 and the last paragraph in 0874-20. This is the second enhancement paragraph. I'm going to take your plea to it for purposes of the allegations in that paragraph in both indictments because they're the same. It's further presented that prior to the commission of the primary offense and after the conviction in cause number 791-416 was final, it's alleged you committed the felony offense of driving while intoxicated. Furthermore, and that you were finally convicted on the 29th day of August 2013 in cause number 0070576-13 and the 7th Judicial District Court of Smith County, Texas. Is your plea to each one of those allegations in each paragraph of the indictment, the last paragraph, true or not true?
True.
Are you entering your plea of true to the allegations in the third paragraph of the driving while intoxicated indictment and the second paragraph of the possession of a controlled substance indictment freely, intelligently, knowingly, and voluntarily?
Yes.
Has anyone threatened you in any way or promised you anything to enter your pleas of true to those allegations in the third paragraph of the driving while intoxicated or the second paragraph of the possession of a controlled substance?
No.
The court then does receive and accept your plea of true to the allegations in the fourth paragraph of the indictment charging driving while intoxicated in 0873-20. Court finds those allegations in the third paragraph of that indictment to be true, charging a prior felony offense of burglary of a building. And the court does receive and accept your plea of true. The court does find as true the allegations in the second paragraph, the same allegations alleging a prior felony conviction for burglary of a building under the offense of possession of a controlled substance is charged in 241874-20. Court finds those allegations in those paragraphs of each indictment, which are the same, to be true. Moving now to the last paragraph of each one of the indictments. I'm going to read it to you again one time, Mr. Moss. I'm going to be asking you the same question. Is your plea true or not true? I'm taking your plea of true or not true to the allegations in the last paragraph of each indictment at the same time because they are the same. Do you understand that?
Correct.
It is further presented that prior to the commission of the primary offense and after the conviction in cause number 791-416 was final, it's alleged that you committed the felony offense of driving while intoxicated. Furthermore, and you were finally convicted on the 29th day of August 2013 in cause number 0070576-13 in the 7th Judicial District Court of Smith County, Texas. For purposes of your plea to these allegations just read to you by the court in the enhancement paragraphs, the last paragraph of each indictment, is your plea true or not true?
True.
Are you entering a plea of true freely, intelligently, knowingly, and voluntarily to the allegations just read to you by the court from each indictment?
Yes.
The court does receive and accept your plea of true to the allegations in the last paragraph of each indictment. The court does find those allegations to be true. The court, having found the allegations in the third paragraph and the fourth paragraph in the indictment 24-108-73-20 charging driving while intoxicated, third degree felony, the sentencing range for that offense, driving while intoxicated third or more, is now enhanced up to the habitual sentencing range of not less than 25 years or more than 99 years of life in the Texas Department of Corrections Institutional Division. Do you understand that, Mr. Moss?
Yes.
Over in cause number 2410874-20, the court, having received and accepted the defendant's pleas of true to the allegations alleging prior convictions for felonies in the second and third paragraph of that indictment, where the charge with possession of a controlled substance. The sentencing range in that indictment in 2410874-20, charging possession of a controlled substance, is now enhanced up to a second-degree felony, not less than 2 years nor more than 20 years in the Texas Department of Corrections Institutional Division. Fine may be assessed at up to $10,000. Do you understand that, Mr. Moss?
Yes.
Now, Mr. Moss, in each set of plea papers, and the first one's the indictment's up on the screen right now in cause number there. We're moving on to the plea papers.
Right.
Over in cause number 2410873-20, that's the driving while intoxicated, third or more.
Right.
You understand you're starting off there with a third-degree felony, not less than 2 no more than 10, fine of up to $10,000, but it's been enhanced up to, based on your pleas of true to the priors, up to a full sentencing range now, which stands at not less than 25 years, no more than 99 years of life in the Texas Department of Corrections Institutional Division for the driving while intoxicated, third or more. Do you understand that, Mr. Moss?
Yes.
All right, over in the other indictment, that's the possession of controlled substances started out as a state jail felony. Based on your pleas of true to the allegations in the second and third paragraph of that indictment, the sentencing range in 2410874-20, where you charged with possession of controlled substance, that is now enhanced up to a full sentencing range of not less than 2 years, no more than 20 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. Do you understand that?
Yes.
All right, now all these plea documents, I may have asked you earlier sometime back now, one of the plea documents up on the screen is going to be your agreed punishment recommendation. I just want to ask you, there's a signature on the line above where it says defendant that'll be pulled up on the screen right there. It's signed. I can easily read the signature. Calvin Moss. I have to ask you for the record, is that your signature?
Yes.
That signature is on all the plea documents along with your attorneys, Mr. Don Davidson, in both these cause numbers. Now, I'll identify the plea documents that I have, and I have these plea documents in both cause numbers. We've been over the plea agreements to the point of the full range of sentencing. In cause number 2410873-20, where you're charged with driving while intoxicated, now it's enhanced up to a first-degree felony carrying a sentencing range of not less than 25 or more than 99 years of life in the Texas Department of Corrections. If you do plead guilty to the offense of driving while intoxicated, third or more, enhanced in cause number 2410873-20, your plea agreement, as you can see on the screen in that cause number, is Ms. Anderson, state's attorney, is going to recommend your sentence at 25 years in the Texas Department of Corrections Institutional Division, which would be assessed with credit for time served. You'd be ordered to pay a $60 fee to the Department of Public Safety for the blood draw. Is that your plea agreement in that case, Mr. Moss?
Yes.
Is that your recommendation, Ms. Anderson?
It is, Your Honor.
Is that the plea agreement, Mr. Davidson, in that case?
Yes, Your Honor.
Over in cause number 2410874-20, Mr. Moss, that in that case, that's the possession of a controlled substance has been enhanced up to a sentencing range of not less than 2 no more than 20 years in the Texas Department of Corrections Institutional Division. Fine may be assessed up to $10,000. Your agreed punishment recommendation in that case is if you do plead guilty, Ms. Anderson is going to recommend your sentence at 20 years in the Texas Department of Corrections Institutional Division. That would be assessed with credit for time served. You'd be ordered to pay a $180 lab fee to DPS in that cause number for the drug analysis. Also, part of your plea agreement is that the sentence assessed by the court in each cause number, that would be, I'm going to follow the plea agreement, so your sentence will be assessed by the court for the offense of driving while intoxicated, enhanced up to habitual. The court will follow the plea agreement and assess your sentence there at 25 years and over where you're charged with possession of a controlled substance, enhanced up to second-degree felony. The court will follow the plea agreement and assess your sentence at 20 years in that cause number. Also, as part of the plea agreement, each sentence will be ordered to run concurrent at the same time with credit for time served with restitution ordered to DPS for the blood draw and then for the drug analysis. Are those your plea agreements in both cases, Mr. Moss?
Yes.
Those are the plea agreements, Ms. Anderson and Mr. Davidson.
That's correct, Your Honor.
Yes, Your Honor.
All right, and I'm going to go through now for purposes of the pleas in both cause numbers, and I'm going to identify all the plea documents I have in each cause number. The plea agreements have already been over 25 years recommended by the state for the offense of driving while intoxicated, third or more enhanced up to a habitual, 20 years over in the offense for possession of a controlled substance enhanced up to a second degree. The court will follow the plea agreements, assess the sentences recommended by the state. They'll be ordered to run concurrent with credit restitution order. So I've got those plea agreements. I've got an acknowledgement of admonishments. All these are signed and sworn to you by Mr. Moss. Do you understand in each cause number all 5 admonishments?
Yes.
Do you understand in each cause number, there's a waiver of trial by jury going up? That waiver of trial by jury is signed by you and your attorney, and each cause number that waives and gives up your right to a jury trial and tells the court you wish to proceed on your plea of guilty without a jury. Do you understand that for purposes of both cases, Mr. Moss?
Yes.
You signed and sworn to in each cause number a waiver of confrontation, witnesses, and agreement to stipulate evidence. In each cause number, there is a stipulation of evidence, Mr. Moss. My question to you there is the stipulation of evidence, which is marked as stage 2, in each cause number, that is a written judicial confession under oath by you, the stipulation of evidence in each cause number to all the allegations and the charge in each indictment. Do you understand that?
Yes.
Did you sign and swear to the stipulations of evidence, stage 2, in each cause number, freely, intelligently, knowingly, and voluntarily?
Yes.
All right, the court then does approve the stipulations of evidence, states exhibit number 2 in each cause number. Each cause number has an agreement to stipulate testimony. Each cause number also has plea agreements there's a waiver of your right to file, gives up your right to file a motion to new trial, and a waiver of appeal. It waives and gives up your right to appeal in both cause numbers. Do you understand that, Mr. Moss?
Correct.
Also, the court has signed in each cause numbers approving waivers of the pre-sentence in each cause number. Then in each cause number, Mr. Moss, you have signed, along with your attorney, a trial court certification of your defendants, your rights to appeal, which is shown, checked by each one above your signature and Mr. Davidson. Each of these cause numbers is a plea bargain case, and you have no right of appeal, and also that you have waived your right to appeal in each cause number. Do you understand all of that, Mr. Moss, in both cause
Yes.
numbers?
Yes.
All right, I'm going to go through, having identified all of these plea documents and the full range of sentencing and gone over all the plea documents in each cause number, as well as the plea agreements in each cause number. I'm going to go through and ask you some questions now. All the questions I'm asking now apply to your pleas in both cause numbers. Do you understand that, Mr. Moss?
Correct.
And it is still your decision to go forward on your plea of guilty to the indictment in each one of these cause numbers with these enhanced range of sentencing with your plea agreements in place without a jury. Is that correct?
Correct.
All right, for purposes of both indictments now, do you read, write, and understand English?
Yes.
Have you consumed any alcoholic beverage in the last 24 hours?
No.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No.
Have you ever been confined in a mental institution or under psychiatric treatment?
No.
Do you understand everything you're doing in court today?
Yes.
Have you been over everything about the facts of your cases and everything you're doing in court today with your attorney, Mr. Don Davidson?
Yes.
Is he competent, Mr. Davidson?
Yes, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, Your Honor.
Court does know state's counsel, signed her includes the waiver of trial by jury. The court approves the waivers of trial by jury and all the other waivers in each case signed by the defendant, signed by his attorney. All right, now, Mr. Moss, you understand the allegations, the charge in each indictment, the full range of sentencing, your plea agreement in each cause number, and all the plea papers in each cause number. Is that correct?
Correct.
Do you have any questions for me about anything?
No, sir.
All right, and first of all, we're going to start in cause number 241-0873-20. What is your plea today to the indictment in that cause number charging you with driving while intoxicated, enhanced to a habitual range of sentence?
True.
I'm going back to the indictment itself. In other words, I'm asking you what your plea is today to the indictment in this cause number charging you with driving while intoxicated, third or more, enhanced to a habitual.
Guilty.
Are you? And I'm going to go over to the next indictment, cause number 241-0874-20, to to the offense in that indictment, charging you with possession of a controlled substance enhanced up to a second-degree felony, is your plea to the indictment in that cause number charging possession of a controlled substance guilty or not guilty?
Guilty.
Are you entering your pleas of guilty to the indictments, to the indictments in each case today because you are guilty and for no other reason?
Yes.
Has anyone threatened you in any way or promised you anything to get you to plead guilty in either cause number?
No.
Are you entering your plea of guilty to the indictment in each cause number today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you by the indictment in each cause number?
Yes.
Are you entering your plea of guilty to the indictment in either cause number today as a result of any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No.
All right, the court does receive and accept your plea of guilty to the indictment in each cause number, finding the pleas of guilty were entered freely, intelligently, knowingly, and voluntarily to the indictments in each cause number. Court having received and accepted the defendant's plea of guilty to the indictment in each cause number, court having found each plea of guilty was entered into the indictment, each cause number freely, intelligently, knowingly, and voluntarily. The court having found the defendant guilty of the offense alleged against him by the state in its indictment at each cause number. Moving to sentencing, Ms. Anderson.
Your Honor, before we move to sentencing, just for the record, I'd offer in each cause number states 1, 2, and 3, the plea packet with signed waivers and admonishments, the stipulation of evidence signed and sworn, and also the discovery compliance documents.
No objection.
With no objection in each cause number, the court admits into evidence states 1, all the plea documents, states 2, the signed and sworn 2 stipulations of evidence, written judicial confessions under oath by the defendant, the allegations in each indictment. States 2 is admitted into evidence in each cause number. States 3, discovery compliance admitted into evidence in each cause number with no objections. The court having received and accepted, admitted into evidence states exhibits 1, 2, and 3. The court having received and accepted the defendant's plea of guilty, finding each was entered freely, intelligently, knowingly, and voluntarily. The court finding the defendant guilty of the offense alleged against him by the state in each cause number. The court follows the plea agreements and the recommendations of the state in each cause number. The court does assess the sentence at 25 years in the Texas Department of Corrections Institutional Division with credit for time served for the offense of driving while intoxicated, third or more, as alleged in 2410873-20. Court orders restitution in that cause number in the amount of $60 for the DPS lab fee for the blood draw. In cause number 2410874-20, court having received and accepted the defendant's plea of guilty and having found the defendant guilty of the offense alleged in this indictment, possession of a controlled substance enhanced to a second-degree felony, the court does follow the plea agreement with the recommendation of the state. The court assesses the sentence in this cause number 20 years following the plea agreement in the Texas Department of Corrections Institutional Division. Lab fees assessed at $180, DPS for the lab fee analysis. Court having received and accepted the defendant's plea of guilty in each cause number, and the court formally pronounced his sentence in each cause number. There's no legal reason to bar formal sentencing, is there, Mr. Davidson?
That's correct, Your Honor.
Court formally pronounced his sentence in each cause number, having received and accepted the defendant's plea of guilty. Following the plea agreement, sentence is formally pronounced in cause number 2410873-20. Court finding, having found the defendant guilty of the offense of driving while intoxicated, third or more, the court following the plea agreement is formally pronounced his sentence of 25 years in the Texas Department of Corrections Institutional Division, assessed with credit for time served, $60 assessed as the lab fee in that cause number to DPS for the blood draw. Cause number 2410874-20, court formally pronouncing sentence. Court does find the defendant guilty of the offense alleged in the indictment, possession of controlled substance enhanced to a second-degree felony. The court follows the plea agreement, assesses the sentence at 20 years in the Texas Department of Corrections Institutional Division, assesses a lab fee of $180 to DPS to be ordered as part of the sentence. Each one of these sentences with the court following the plea agreements is ordered to run concurrent or at the same time. And sentence is formally pronounced, no reason to bar formal sentencing, correct, Mr. Davidson?
That's correct, Your Honor.
Court then formally pronounces sentence. Court in each cause number does find the defendant guilty of the offense alleged against him by the state in each cause number. Court follows the plea agreement in each cause number, assesses the sentence of 25 years in Texas Department of Corrections Institutional Division with credit and restitution ordered in 2410873-20 for the offense of driving while intoxicated, third or more enhanced. Court, having received and accepted the defense plea of guilty, the court does find the defendant guilty of the offense of possession of controlled substance enhanced to a second-degree felony in cause number 2410874-20. Sentence is formally pronounced with the court following the plea agreements, the recommendation of the state in each cause number. The court does receive and accept the defendant's waiver of appeal in each cause number signed by the defendant, signed by his attorney, also accepts and approves the defendant's waiver of a motion for new trial in each cause number signed by the defendant, signed by his attorney. Sentence is formally pronounced by the court in each cause number. The sentences having already been ordered by the court to run concurrent or at the same time with credit. The defendant is continued in the custody of the sheriff until he can be transported to the Texas Department of Corrections Institutional Division to serve the 25-year sentence set by the court in cause number 2410873-20 for the offense of driving while intoxicated, third or more enhanced to a habitual, and until he can be transported to the Texas Department of Corrections Institutional Division to serve the 20-year sentence set by the court following the plea agreement in 2410874-20 for the offense of possession of controlled substance. Both sentences assessed by the court following the plea agreements are ordered to run concurrent at the same time with restitution as ordered by the court. Credit for time served granted on each sentence. Waivers of appeal, waivers of motion to new trials accepted, approved by the court in each cause number. Ms. Anderson, anything further?
Your Honor, I just offer states 4 electronic copy of the written discovery, a single copy for both cases.
No objection.
With no objections, thank you, Ms. Anderson. With no objection, states 4, that would be all the written and other judicial discovery, if there is any. Discovery compliance is met. Discovery is admitted into evidence under states 4 in each cause number with no objection. Defendants continue in the custody of the sheriff then until he can be transported to the Texas Department of Corrections Institutional Division to serve the sentence assessed by the court following the plea agreement. Each cause number with credit time served, restitution ordered as determined by the court and dictated into the record. There's nothing further, Ms. Anderson. We'll be in recess.
Nothing further, Your Honor.
Anything any further, Mr. Davidson?
No, Your Honor.
We're in recess. Mr. Miles continues in custody of the sheriff till he can be transported to Texas Department of Corrections, serve the sentences assessed by the court with credit for time served, order to run concurrent. We're in recess. Let me see what I got. How much got to come through?
That's supposed to just be a dismissal.
I'm sorry, couldn't you?
Dismissal.
All right, let me take a look at what we got here by Zoom. We got calls number 2412087-19, State versus Randy Rocha, ROCHA. Let's just take about a 10-minute recess. I don't see the defendant yet.
Judge, it's going to be a very short announcement. He's there at low risk.
I just don't see him. I just don't see him yet. I see
There he is.
I see Mr. Gilmore.
Yeah.
All right, and I see my probation officer, and now I see an individual who's, that would be Randy Rocha, correct, Mr. Davidson?
That's correct, Your Honor.
All right, then the court's calling by Zoom with the defendant Randy Rocha present by Zoom. Court's calling calls number 241-2087-19 on the state's motion to adjudicate guilt filed July the 23rd, 2020. And the court's calling state's motion to adjudicate guilt over in calls number 241-2088-19 filed marked July the 23rd, 2020. So for purposes of announcements, Ms. Anderson or Mr. Davidson, whoever wants to go first.
I believe Mr.
Oh, I'm sorry,
Gilmore-
Mr. Gilmore. Go ahead. I had Ms. Anderson. Go ahead.
Sorry, Your Honor, I was on mute.
Mr. Gilmore is present for the state. Mr. Davidson for the defendant. The defendant is on Zoom with us at this time. Go ahead.
And Your Honor, the state has an announcement. If you remember, Your Honor, we were having a hearing on this case last week, and it was ordered by the court that Mr. Davis and I meet with probation and come up with amended conditions for the defendant. Those conditions have been written, and I believe they are before the court in a motion to withdraw the motion to communicate and amend the defendant's conditions.
All right, let me get those. Just a minute, Mr. Gilmore. I recall that now that you brought it to my attention. So in each cause number, I don't recall how far you may, we got.
And Your Honor, I do have the conditions here, and I can just read them to the court if you prefer.
Let me see, in each cause number, I've got an order. And I believe what you just said, Mr. Gilmore, is that you now have there in front of you, and I've got them in the order here. I'd ask the state and defense to come up with additional conditions of probation in each cause number. So apparently, obviously, we'd gotten down to the point I do have, just for the record, in each cause number, a motion of the state to withdraw its motion to adjudicate and amend the terms and conditions of community supervision in each cause number. Then each cause number, that's over Mr. Gilmore's signature. Then each cause number, the court has an order, which is set out, setting out those additional terms and conditions of probation. I believe they are the same appears in each cause number. So I'm going to read them into the record, Mr. Rocha. Just raise your right hand for me, because I'm going to have to ask you a couple of questions. You solemnly swear to affirm the testimony you'll give before the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir, I do.
All right, Mr. Rocha, I'm going to go over the orders. The orders appear to be the same in each cause number. The state has filed motions to withdraw their motion to adjudicate in each cause number. That motion to withdraw its motion to adjudicate in each cause number amends the terms and conditions of your community supervision. Obviously, as you already know, the court's going to grant each one of those motions to withdraw filed by the state. They're withdrawing their motions to adjudicate. They're amending the terms and conditions of the community supervision in each cause number. You know, if the state had proceeded on the motions to adjudicate with alleged violations of your deferred adjudicated probation in each cause number, if the court found those allegations to be true, the court would grant each motion, adjudicate each case, go back, find you guilty, and then because you were on deferred, the court could assess your sentence up to the maximum. You understand that's what could have happened, Mr. Rocha?
Yes, sir, I do fully.
Now, as a result of the motion of the state to withdraw its motion to adjudicate and amend the terms and conditions of community supervision, the court is going to follow that recommendation of the state in each cause number. This is the order that the court is going to sign in each cause number. It is therefore, number one, the order grants the state's motion to adjudicate in each cause number. And then you'll see it on the screen. It is therefore ordered, adjudged, and decreed by the court that the motion of the state to withdraw the motion to adjudicate you as stated above being the same is hereby granted in each cause number, and the conditions of community supervision heretofore granted in each cause number be in all things continued in full force and effect. So first of all, in each cause number, Mr. Roach, all your present terms and conditions of your deferred adjudicated probation in each cause number still apply. Do you understand that?
Yes, sir, I do.
They are amended as follows, with amended conditions as follows in each cause number. 34 at your own expense. You can see them on the screen. 34 at your own expense. Submit to a urinalysis each week as directed by your supervision officer until further order of the court. Do you understand that condition?
Yes, sir, I do.
Also 54, you are assigned to a level 2 intensive supervision for a term of 1 year, and during this term you're ordered to report each week as directed by your supervision officer to the probation department. Do you understand that?
Yes, sir, I do.
59, you're ordered to submit yourself to the beginning program for intensive outpatient substance abuse counseling counseling program as directed by your supervision officer, and remain in that program and abide by the rules and regulations of that program. Successfully complete the beginning program within 180 days of today. Do you understand that, Mr. Roach?
Yes, sir.
In addition, condition 70, The term of community supervision is extended for an additional period of 1 year to wit, in other words, you'll be on the deferred adjudicated probation up until, unless it's extended again, you'll be on till the 3rd day of August, 2026. Do you understand that? In each cause number, Mr. Rocha?
Yes, sir, I do.
71, immediately. Immediately means before you go anywhere else. Immediately upon being released from the Smith County Jail, you will be required to contact your supervision officer, Ophelia Ramirez, at the phone number that's set out in these conditions that Mr. Davidson has, and of course you will have them. Supervision officer Ophelia Ramirez will provide you with your reporting instructions today. Do you understand that?
Yes, sir.
So when you book out of jail, it's a term and condition of your community supervision that upon being released from the Smith County Jail, you're required to contact your supervision officer, Ophelia Ramirez. You'll have the number on paperwork you'll get when you book out, but you have to contact her today. If you do not contact her today, either in person or by phone, it'll just cause another no bond warrant for your arrest to go out tomorrow. Do you understand that?
Yes, sir, I do.
Now, you also understand I'm going to sign all these conditions or amended conditions in both cause numbers. I want to be sure and make this clear to you. Now, the state is giving you an opportunity, and the court's following the recommendations to amend these terms and conditions of your deferred adjudicated probation rather than the state proceeding on its motions to adjudicate, which could, if the court found the allegations true, cause you to be convicted of the offense charged in each indictment. You could be sentenced up to the maximum. You understand that, Mr. Rocha?
Yes, sir.
Do you understand I won't do this again? I'm following the state's motion to withdraw its motion to adjudicate and amend the terms and conditions of community supervision. I'm doing it today, one time. If there's any other violations reported to the court, I'll immediately issue no bond warrants for your arrest as I did before in each cause number, and then I will not accept any motion by the state to withdraw its motion to adjudicate unless for some reason they decide there's no grounds to file it. I would not accept what we're doing today again. Do you understand that?
Yes, sir, I do.
The reason is obvious. You started off getting deferred adjudicated probation. You violated, as alleged by the state, conditions of your deferred adjudicated probation. And now, instead of being sent to confinement in the state jail or the Texas Department of Corrections Institutional Division, now you're being given the opportunity to go back on deferred adjudication with amended terms. So if you violate again, then you would expect, I would think, to be sent to be incarcerated for the term determined. It's in by a jury for the term determined and set by the court, which can be all the way to the maximum in each case. Are you with me on all that, Mr. Rocha?
Yes, sir, I am.
What's the first thing you're going to do when you book out of jail, whenever it is, on both these cases?
Call my officer right away, sir.
Correct, and you'll have that. And the court's probation officer, Marcella, Ms. Flores is present here by Zoom listening to all this from the probation department. And you will have paperwork that will give you your supervising probation officer, Ms. Ramirez's name and number so that you can contact her today. Marcella, Marcella, is there anything else I need to go over for purposes of probation?
No, Your Honor, he just needs to make sure that he makes contact with Ophelia Ramirez today so we can give him reporting instructions.
Okay, did you hear all that, Mr. Rocha?
Yes, sir, I did. Thank you.
The purpose of you're welcome. The purpose of you contacting your supervision officer today by phone is so, as Ms. Flores just said, so your probation officer can set up a date and time for you to report in person to the probation department. Now, when you if you don't contact her today, a warrant will go out. Once you contact her today, then she's going to give you a date by which you have to personally appear at her office to go over all the probation new terms and conditions, as well as all the others, including the ones you allegedly violated. So you got to contact her by phone today, then report in person on the date she gives you, the date and time she gives you. If you fail to do either one, it'll trigger a violation report from the probation office and another pair of no bond warrants for your arrest. You understand all that, Mr. Rocha?
Yes, sir, I do.
Do you have any questions for me about anything?
Not at the time. It's very clear.
All right, anything else, Mr. Gilmore?
No, Your Honor, not on this matter.
Anything else, Mr. Davidson?
No, Your Honor.
Marcel, is there anything else that I need to go over further?
Nothing further, Your Honor.
All right, we're going to be in recess and the court signing the orders, granting the motions of the state to withdraw its motion to adjudicate and amend the terms of community supervision in each cause number. If there's nothing further, we'll be in recess on each cause number. Defendant's continued in custody until he can be released on the terms and conditions of probation to contact his supervising probation order officer upon release from jail. We're in recess.
And Mr. Rocha?
He's gone. I didn't do that. He did. They did.
Oh, they did. Okay.
What do you need on him, Don?
Oh, Marcella had asked me to get a phone number. I don't know how to get a phone number.
Call 3006, 590-3006 and tell him you need to get a phone number before he's released.
Okay.
You got the number, Don?
590-3006.
Denise, what's the number?
He got it. 590-3006.
Okay, I'll give him a call and get back to Marcella.
Right, that's correct. She'll need a phone number so she can contact him if he doesn't contact her, so we won't have to get into a situation with two more warrants. There's nothing
Right.
further than Mr. Davidson, you can get the phone number.